What's the date? It is the 15th. 15th. Good afternoon. It is March the 15th, 2022. Chairman Kiesling always does that to me, so I'm just getting even with everybody on this side. So it is 4:30 in the afternoon, and this is Corrections Subcommittee. And Madam Clerk, will you take the roll?
Representatives Eldridge, Kiesling, Littleton, Moon, Powell, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Are there any personal orders for anybody? No, we want to get out of here. I understand. Okay. All right. First up then is House Bill number 2875 by Leader Camper. Leader Camper, you're recognized.
Thank you, Mr. Chairman and committee members. Thank you for that motion and second. What this bill does, Mr. Chairman, for the last 3 years, we've been working with TDOC to have a bill where women who are incarcerated and are pregnant are not shackled during their delivery. So we are trying to pass legislation to make sure that that doesn't happen in the state of Tennessee. President Trump passed this legislation at the federal level in 2018 under the First Step Act. This bill is also consistent with ALEC's model policy, saying that it creates dignity for incarcerated women, specifically finds that the use of restraints on incarcerated pregnant people may be extremely dangerous to the health of the mothers and the baby. This is really codifying what we actually do. So that's what I'm trying to do with this legislation. Almost every bordering state around us have these anti-shackling laws. South Carolina, Kentucky, Arkansas, Mississippi, Georgia, and Tennessee, I would say, should not be left behind when it comes to that. I think this is something we need to be doing. We have support from medical groups, leading correctional agencies, American College of Obstetricians and Gynecologists, American College of Nursing, like I said, the American Legislative Exchange Council, the Federal Bureau of Prisons, U.S. Marshals. We have a lot of support for this type of legislation. And I've worked with TDOC for the last 3 years to get it in a position, in a posture where everyone agrees that this is good for Tennessee, for mothers and for babies. So with that, I would hope that you can pass this bill out of here and we can move on to full and get this into law.
Okay, thank you, Leader. And you've heard an explanation of the bill. Are there questions from the committee? Chairman Kiesling.
Thank you, Chairman. Leader, I appreciate this. I mean, you've worked hard on this. There's been a lot of parties involved in this. I have had a discussion with at least one of my sheriffs. Successfully, I was able to reach one of them today, even this last moment, and that was intentional because I wanted to check with them today on today's date of the committee. But to me, there's just some in my discussion with one of my sheriffs. He's just fearful of the potential liability. I get it, and I understand it, but still, there's that sliver of chance and opportunity of liability that could come back on my county or counties for that matter. Again, I commend your effort, but I'll be going down on it. But I just wanted to go ahead and take a moment to thank you very much for your time and attention on this. Thank you very much. And Mr. Chairman, thank you for the opportunity. Thank you.
Thank you. And also, before we go any further, You had an untimely filed amendment. Doesn't guarantee that the committee will put it on because it's untimely filed, but do you still want that? Because, go ahead.
I do, Mr. Chairman. I didn't realize it was untimely file. This is the approved language that I work with TDOC on. So,
Okay,
yes, I do need to have that on.
Yeah, you made reference,
I
but
do.
it's not on there. So.
Roger. Thank you, Mr.
Okay.
Chairman.
There is a motion on the amendment to
got
consider
a motion
the
to consider.
untimely filed amendment.
Yeah.
Do I have a second? I'm sorry. The motion to add the amendment fails. So the bill as written is what we're considering now.
Okay.
Is there anything else from the committee? Yes, sir, Representative Powell.
I mean, I've had the privilege of being on this committee for 4 years now, and I know we've heard this a couple different times. You know, I think this is an important issue. If I could, because I just want to make sure we get this on the record, because and I realize we're not looking at this amendment now, but was just trying to get clarification that, if I could, from legal, that essentially, as written, there was some sort of confusion, I think, going around that maybe handcuffs would not be allowed anymore, or something in the legislation. I just want to clarify that that's not the case.
We need to go out of session. Okay, there's been a question to legal. We'll go out of session. You're recognized.
Thank you, Mr. Chairman. Representative Powell, could you ask your question again? I'm not sure I followed.
So there was some basically information saying that if passed, this bill would not allow for the use of handcuffs anymore. Can you confirm if that's the case?
I believe in the situation that is trying to be addressed here when a prisoner is pregnant, then that definitely could be the case, that because it says that no restraints could be used, and in the definition of restraint, hard metal handcuffs is part of that definition.
Okay, but that's in the case of specifically in the case of childbirth. And I realize we don't have the amendment that might have, but I just want to make sure. I mean, so essentially handcuffs would still be able to be used.
When you say that they would still be able to be used, are you talking about on a
Yeah,
pregnant
this bill is
person?
not going to. Yes, this bill is not going to prevent the use of handcuffs.
Unless there was an individualized determination that the prisoner or detainee presents an extraordinary circumstance that dictates the use of restraints to ensure the safety and the security of the prisoner or detainee.
Okay, so I just and I think I appreciate that. I guess we could go back to the session, Mr. Chairman. That answers my question from legal.
Leader.
Thank you, Mr. Chairman and members. Representative Keisling, I understand.
1 second. I've got to go back in session because we're still out. Anybody? Any other questions for legal? Representative Littleton.
Could he repeat that just one more time about the handcuffs, please? And restraints.
Thank you. So the bill says that a correctional institution shall not use restraints on a prisoner or detainee known to be pregnant unless the corrections official makes an individualized determination that the prisoner or detainee presents an extraordinary circumstance that dictates the use of restraints to ensure the safety and security of the prisoner or detainee.
Thank you.
Any other question for legal? Okay, we're going back in session. Now, Leader Camper, I'm sorry, go ahead.
That's all right. I thought you came back in, Mr. Chairman. Thank you. I appreciate that. So, Representative, I understand your concern about your sheriffs and their concern. Except I just learned that when I walked in this room. And I'm a little upset about it, which is how I probably came off the way I did initially, because I felt blindsided by that. But I get it. They feel that way. But let me just tell you about some liability. We just recently had a lawsuit from a woman who was delivering, and they had her shackled for over 6 hours. She ended up with a blood clot. So that's costing the state money, not this potential liability that we believe might be. This is something that actually happened in the state of Tennessee. So I get they may have their opposition. I believe that what this committee could do is we could pass it to full. I can work with them on an amendment that they may be agreeable to, because I never had a chance to talk to them about it till I walked in this room. And so if this committee could work with me on that, I'll park it in full if I cannot address their issues. But you are saying the U.S. Marshals don't have a problem with this. And there are so many other credible organizations that don't have a problem with this, that have been working with us diligently for 3 years. And today, I walk in the committee, and this is what I hear. It just bothers me. So what I would ask this committee to do is to move it out to full, since this is your final calendar. Allow me the opportunity to work with the sheriffs, which they're here. There they are. That they would be willing to do. And if we can't fix it, we can't fix it. That's the only thing I'm asking of this committee right now. Thank you, Mr. Chairman and committee.
Thank you, Leader. Are there any Representative or Chairman Littleton?
Could we go out of session and hear from the Sheriff's Association, please? I think they're here.
We can.
Thank you.
All right, we're out of session. Mr. Bledsoe, would you like to come forward? And you can either stand at the podium or you can take a seat. And please make sure your mic is on and state your name, please.
Hello, committee. I'm Jeff Bledsoe, the Executive Director for the Tennessee Sheriff's Association.
Representative Littleton, go ahead.
Could you please tell us what your concerns are?
Well, first, I wasn't aware that we haven't had that conversation with Representative Camper, and I apologize for that. I think we had tried, but maybe there were some misses on making that connection. But one of the things that has stood out to us that we always teach our jail staff, our deputies, is that we cannot create a deliberate indifference in a jail environment in which we treat one inmate different than another inmate. And if we take certain diagnoses, medical confirmation, say a pregnancy in this occasion, and we use that and treat that inmate differently than we do another inmate that may have a bad back or a bad leg, then we create a deliberate indifference at that point. So we have concerns with that as we move forward with it, but our duty as sheriffs is to protect all. And as you look at restraints and go back for centuries, the restraints are used just to limit that movement and exposure. And even people that are cuffed have been known to overpower staff and take their weapons. And so every time we go outside the facility with anyone that's in custody, we're taking a risk of what that could entail. And sheriffs do not have the staff that U.S. Marshals have or perhaps TDOC has. We may have one deputy that can cover a transport for a medical appointment, an evaluation, or a court appearance. Once they get in court, we usually have bailiffs and more security in the courtroom or detention facility or area within the jail. But upon those movements and transfers, that's where those risks can surface. And just because an inmate's pregnant does not mean they're incapacitated, and we do not know what's in everyone's mind as to what their attempts or their actions could be. We have to prepare for the worst and hope for the best, and restraints help us to protect ourselves, to protect the inmate. If we're transporting multiple inmates and one is not cuffed because of this becomes law and they decide to assault another inmate because they are free to do so, then we're responsible and liable for that. one of the things that we always did when I was sheriff is we have our medical team. Not every jail has that. We're talking about jails that may have 1 or 2 deputies that care for the jail and the inmates and the other staff that's there. But we have our medical team evaluate the person, and if they have difficulty walking or they're having a difficult pregnancy, then we would put them in a wheelchair, or we had a gurney in our facility too that we could put them on and wheel them to where they needed to go. We could put a wheelchair in the car and wheel them into court or medical appointments. And there's a lot of things that we can do outside of just saying, don't do this because of certain situations that's happened. And I spoke to one sheriff, and I don't think we've heard the whole story on the one female that he had to shackle to a 4-seat bench. He used 2 shackles so that she had an extended movement. She wasn't just tied to a chair. And the reason he did that because he does not have a facility that houses females. And when this female kept violating probation for testing positive on drug screens, the judge ordered her into custody, and no other jail that he normally deals with would take the inmate because she had a high-risk pregnancy because of drug use. So he had to keep her in his facility without a holding cell for her. And the previous pregnant inmate that he had that he did not shackle to anything went into a side room, took a light bulb, broke it, slit her wrist, and then they had to care for her and all the bills and get her to some mental health therapy and everything. So based upon him knowing there's a risk for not detaining her or restraining her in a certain way, he had to do that to limit his liability. But she had movement, she could stand, she could walk, she had what's called a boat or a plastic type large tray that a mattress pad goes in. So she had accommodations of whatever the facility could supply. She just didn't have an isolated area that they could confine her in.
Any more questions? Yeah, Chairman Moon.
Thank you, Mr. Chairman. How prevalent is pregnant inmates in county jails?
I'll just speak from my experience. It can be regular, and at times I'd be hit with more than one, but it's not as prevalent as maybe what you would think, because we have other resources to where if it is a high-risk pregnancy, we can look at special needs with the state, or we can work with the court. But we have those inmates that cannot be outside because we've seen that they're still using drugs, narcotics, and they're doing things they shouldn't do. And they're not only placing themselves at harm, but they're placing the unborn child at risk. So therefore, the court intercedes, and we do our best then to make sure that they're safe in our jail environment.
I'm sure when things go to court, the first thing is policies and procedures.
Yes, sir.
And having your knowledge and background, do you find that there's a lack of adequate policies and procedures at that institution?
Within the jail
Within the
institution?
county jails. And I'm coming at it from a county standpoint.
It's going to depend upon the leadership that they have, Representative Moon. I couldn't speak on behalf of all. I just know that we've studied this, and our legislative committee gave us a position on it just based upon the restrictions that they have with staff. But policies and procedures are in place at the state level. We have standards of care with TCI and with the jail environment and how we treat everyone, and we're doing our best to keep them safe. And we wouldn't put anyone at risk that couldn't walk or a potential fall with shackles or putting chains or a waist chain on them to where they couldn't catch themselves. And we'd have extra escorts with them if we can, or we would use that chair or the gurney.
Thank you, Mr. Chairman.
Representative Powell.
I guess, could you just give me your opinion on why you think Tennessee is an outlier and we need shackling versus all the states around us that don't allow this?
Well, some of the sheriffs that we've talked to don't use those, so I'm not sure of a number that would say they use them or not. What we would look at when I was sheriff would be the classification. Why is this person in custody? And we would see if they're a risk for flight or to escape. Some of them we have such a hard time even getting them in custody that if they do have that least little opportunity, we think that there's going to be potential attempt to escape. And a lot of times those can be pre-planned or pre-arranged if they know they're going outside the facility. That is our most dangerous point, is once we don't have them inside the facility for control and security measures and they go outside. That's where we've had deputies overpowered before, or they'll plan to have someone there waiting for them over the years that I've seen. But I've looked at our training and from a national perspective, and I found no material that guides us on this. And if it were an issue, I believe our state leadership that does our jail training and our standards and our sheriff's associations, I'm a part of the National Sheriff's Association, we would already be addressing those and working with it. And we're not opposed to sitting down with Representative Camper and seeing what there is to come together on this, because I think sheriffs now aren't putting shackles on them, but there's nothing that says you can't, and then it would depend upon the physical capabilities of the person. Everyone that I've seen that's pregnant, they're not all where they can't function, or if they wanted to fight you, they could put up a fight, and all it takes is that if they get you disarmed.
Yeah. Well, I guess, so I guess what you're saying then in your testimony is you are aware that shackling of pregnant women, especially during childbirth, is going on in Tennessee. Is that right?
No, sir. I'm not aware of that at delivery. I knew of one case that I think there was a court ruling on, and it kind of shocked me that they were in delivery with shackles on. I would not condone that, no, sir.
But shackling of pregnant women in general is still going on
for movements, transports, taking them to doctor's visits or evaluations or court. It's just a standard for all inmates, and to try to treat them all equally and the same.
Okay, and then the legal, you were in here, I know, for when they gave the exclusions that would exist. You don't think that would allow for flexibility with those transports, or not?
There were some exclusions in it, but they were at a much higher level to where basically if you didn't have those on the checklist, you would need to take the shackles off, or no restraints with the waist belt with the cuffs going through it, which restricts the movement. So it would limit what you can do, and we just know from our training and years of experience that those transfers and those transports outside the facility are the highest risk, not only to our staff, but to everyone that's out in the public at that point, at a doctor's office or wherever we're going.
Okay, and I guess we heard testimony about the federal, recommendations that have been made, and then also I know the state has been working on that. I mean, wouldn't you look for best practices at the federal and the state level, and then if they're saying that this isn't necessary, why is it so different for our local jails?
Well, what I've looked at, and I highly respect our federal and especially our state partners with TDOC, is that we do not have the resources that they have. You really would be surprised that if you go across Tennessee, what resources one jail may have versus another. And like this one jail I was talking about where they had to shackle the female, they have 14 beds in their jail, so they are a very, very small facility in small county, and they're probably fortunate if they have one deputy that can schedule that transport to where they can get the person there on time based upon all the other duties that they do. But I would say, based upon what the state and federal government's doing, they're just at a much higher level with their resources or their funding than what some of our counties can handle it. They have more resources. They could probably put 2 deputies on each transport, but there's still a vast number that cannot do that.
Okay, and one more question, if I could, Mr. Chairman. Are you aware of any lawsuits that are pending, of any county jails from pregnant women who have been shackled?
I'm not aware of any, sir. No, sir.
Okay, thank you.
Any other questions for our witness? Chairman Keeson.
Thank you, Chairman. And Chairman Moon brought a question to the director just a few moments ago that lit a light bulb. I serve a county that their jail director hasn't been certified since 1969. It's unbelievable, but that's my understanding. Can you, and I assure you, Chairman, this is indirectly related to the bill, so I'm trying to stay on the bill. But can you tell us how many does TCI, how many are not certified Do you know the status of how many jails are not? I hope there's only that one, but are there others?
No, sir, I wouldn't know that
You wouldn't,
answer
would
to
you?
that. We have discussions when some fail inspection and are
Yeah.
recertified, but I couldn't give you some data on it.
Okay, well, thank you very much, and
Thank you.
thank you for your indulgence, Chairman.
Indeed. Representative Eldridge.
Thank you, Chairman. On the decertified jails, that kind of, it's another light bulb came on there. How would that affect if there was a lawsuit or something like that? I mean, the jail, and our situation is pretty similar. Ours has not been certified in over 20 years. So how would that affect being able to deal with maybe a situation where there's a problem with an inmate that was not restrained or whatever? I mean, I guess I'm getting at that. Does that add more liability, the fact that they are decertified?
From my experience, it's just based upon what you're decertified for. If you have sound policy and procedures that mirror what the standards are, and then on these transports or restraints and movement within the facilities or outside the facility, then we're going to be good standing if we're challenged legally. But it would depend upon what their violations or what those rules were that decertified them. And I think we'd be good if they had the right standards in place or the policy and procedures following them.
Yep. In the case of overcrowding and inadequate staffing, would that increase the liability?
From my experience, it would, and I dealt with that the whole time that I was sheriff. That was the area division that I had the most vacancies in, and we would just have to make sure that everyone was doing their jobs and making everything as far as the standards are concerned and going above them where we could to show that. But I think it could potentially, if you do not have the staff to make security checks and you're skipping on things or cutting corners, yes, sir, with lack of staff, it could create a higher liability.
One other thing, I just texted the chief jailer back home, and they have one pregnant inmate currently in the jail. They don't shackle. They do handcuff in front when they're moving them from one location to the other. And also, I guess my thing, and I guess more of a thought than anything is, are we creating more of a problem than we really have in the Department of Corrections and in their local jail? I'm worried about the local jails. I come from a local background, and they struggle every day, so I don't want to see something that's going to create a greater hardship on them, nor do I want to see an inmate mistreated or anything like that. And I appreciate the fact that my chief jailer she cares enough that that I think that they're very aware of that, and I would hope and think that all the jails would be. But
Yes.
Thank you, Chairman.
Any other questions for a witness? All right, sir. Thank you so much for your time.
Thank you, Chairman.
Appreciate that. All right, we're back in session. Any other questions for the sponsor of the bill? Representative Powell.
Mr. Chairman, I was going to ask, and I know we just went back into session, but I'd actually like to hear from the Department of Correction, if we could, on their perspective. I think it would help enlighten us, too.
That's fine. We'll go back out of session. Please. And please let us know your name.
Thank you, Chairman. Torrey Grimes, Senior Counsel and Legislative Liaison for the Department of Correction. And forgive me, I didn't really come prepared to speak about the bill as originally filed. We did have some concerns with the original bill, and that kind of prompted us to discuss those concerns with the leader. And ultimately, I guess the untimely filed amendment was the language that we were comfortable with. We felt like it captured our current practice. And everything that we do in correction is driven by the inmate's custody and classification level. We felt like the exceptions that were built in what we had agreed upon actually really kind of captured what we were already doing. We don't shackle inmates. We don't shackle inmates. We don't restrain an inmate during the giving birth. We were very interested in this on the bigger sense. Now, obviously, I can't speak for the jails. The jails all of our sheriffs have a different circumstance to deal with than what we have in the Department of Correction. We have about 25 to 30 inmates a year that either come to Department of Correction to give birth and then go back to the county, or you get an inmate coming back on a parole violation. But typically, there's only 3 to 5 inmates annually that are true Department of Correction inmates. So the most of what we get are under the safekeeping statute that allows the locals to commit that inmate to the custody of the Department of Correction. And I believe Director Bledsoe actually referenced that, that the sheriff can go to the judge and seek an order in that regard. But typically, we have designated persons. All those inmates are held here at the Deborah Johnson Correctional Facility here in Nashville. And, the transport and those concerns, we're not going to have the challenges that the local facilities have. Quite frankly, it may be the same correctional officers carrying all of these pregnant females to the hospital to give birth, because that's what we do. We're going to partner. We do partner with Meharry and Nashville General. Absent an extraordinary circumstance, all of these inmates give birth at the hospital in an appropriate setting there. So I hope that covers kind of what Chairman Powell had asked for.
How long do you know has it basically been the practice not to use shackles for pregnant?
Like I said, it's driven by custody level, and to be real, most of the pregnant females we have are going to be the lowest custody level. So, and because of that, absent being handcuffed during the transport, there's not going to be they may be at the hospital without any restraints because it's driven by their custody classification level. And I don't want to impute that the way we do classification is equivalent to how jails do it, because it's not. Because typically everything we do in the Department of Correction from a policy and procedure standpoint is really based on, post-convicted felons that are serving a sentence.
Okay. And, Mr. Chairman, if I could. And then, to your knowledge, the surrounding states, can you speak to their policies, or are you aware? Because I know that we're told that these other states aren't using shackles. Why we might be different in the state of Tennessee needing this?
I don't know that I can directly address that. I mean, everything I know is kind of from the leader's office. I have been aware of some issues that have happened locally. Thankfully, that has not been Department of Correction issues. But I don't know specifics about how other states do it beyond what we did look for in this bill.
Okay.
We did look at some additional states.
But basically, there was an amendment, I know, and that amendment's not before us, but you guys were comfortable in a place working with Leader Camper to basically be fine with this with the amendment.
With that amendment, yes, we were at a place of being comfortable.
Thank you.
The difference, too, is Department of Corrections has access to a whole lot of things the Sheriff's Department doesn't. They have setups, even in the hospital, where you're going to give birth that with a security system that's better than what a jail's got.
Absolutely.
I was troubled by the language, some of the language in the bill that says individualized determination from an officer. If you would get somebody in and have a history. A jail can get somebody in 2 days and not have any history on them. So if a female inmate comes in and she says she's 2 months pregnant or 3 months pregnant, there is no history to determine what level of security they should view her at in that setting. Whereas, I just wanted to point that out.
Well, Chairman, that was language that we were uncomfortable with as well, and the leader took it out of the amendment that was untimely filed.
Any other questions for the witness? Well, thank you, sir, very much. I appreciate your time. All right, we're back in session. Leader, I want to tell you that I believe the Jail Association and Sheriff's Association be more than happy to work out a bill that they're happy with and that you're happy with. If you could consider working on that, but I'm just telling you. Yes, ma'am.
Thank you, Mr. Chairman. I got that feeling too. And that's why I was asking the committee if they were willing to work with me, which he said he was, that if we passed it out and got it to full and it didn't work, this is your all's last calendar, then we would park it there. And,
Well-
and so, I mean, I'm willing to work with them.
That's up to the committee on
I
how they
understand
want to
that.
do that.
I
I was thinking more in terms of if you met with them later and worked on it. But your suggestion's up to the committee. Go ahead.
Well, later today, I mean, we can come back before this committee. I don't have a problem with that either.
Representative Littleton.
I don't think we're going to finish our calendar today, do you? So if we rolled her and let her work on this with the Sheriff's Association, but I think we're all in agreement that the county jails are much different from the prisons. So there are going to be times that they're going to have to be shackled, like in transportation. And we all know that if you're having a baby, I've had 4 babies, you don't need shackles because you're not going anywhere. So maybe we could.
You don't need to be that either, but I feel.
Exactly.
Thank you.
Worse than that. But anyway, I think if she could work with them and try and come up with something about no shackles in delivery, which there's no need for them. But transportation's totally different. If they're wanting to run, I mean, you don't know where they're going to go, what they're going to do, just like we don't know their history. So handcuffs for sure, shackles when they're being transported back and forth. I mean, maybe if you could just come up with something like that, I think everybody on this committee would be comfortable with that.
Okay, thank you. Yeah, and that makes a great point. We have a tendency to focus on somebody delivering a baby being shackled, and your bill doesn't just cover that. It covers anybody who's pregnant. Chairman Moon.
Thank you, Mr. Chairman, and I understand the amendment, the untimely amendment that we did not consider rewrote the bill. But if we do roll this to the heel and don't finish, would the reporting requirements, the searchable database, and these other items be in the bill that may come back before us?
Leader.
Well, I can't say yes or no because I need to talk with them because that could be something else that they're concerned about too. And if there's something they would want me to amend out, I'm willing to work with them on that. And if there's something that the committee or anybody, any other stakeholder, I'm willing to work with them. I've been working on it 3 years and it just hadn't come up. So I'm not against that, per se. I appreciate you bringing it up.
Thank you, Mr. Chairman.
Representative Powell.
So I have a question. I'm going to, if we can, later I'll make a motion that we roll this to heel. But I have a question. If we do that, and if we don't finish the calendar and we're able to take this up, if we again at a later date, are we able to reconsider our action on the untimely filed amendment if we do, as a committee, we do finish today and we want to get this out of here? Because I think, at the very least, at least there was something worked out with the Department of Corrections. And then if she's given her word that she's not going to move this bill out, is that something we would could reconsider, at least if it gets out of this subcommittee, make it a better bill going forward into the next committee, let her work with the sheriffs and get that figured out?
I think we could work through that.
Okay.
But not prior to rolling it to the heel.
Okay, and then I'd make a motion we roll this to the heel of the calendar.
It's been a motion to roll to the heel of the calendar. Any objection? All right, that's exactly what we'll do. Thank you, Leader.
Thank you, Mr. Chairman and Committee. I appreciate that.
All right. Next is item number 2, which has been asked to roll to the heel as well. Next after that is item number 3, House Bill 2332 by Representative Sherrill. That is off notice. Next is item number 4, House Bill 1947 by Representative Dixie. Representative Dixie, you're recognized.
Thank you, Mr. Chairman.
Got a motion? Second? Go ahead.
All right, thank you, Mr. Chairman. So this bill has to deal with doulas, and doulas are non-medical, emotional, and physical support people for pregnant people. This bill is entirely permissive, and TDOC is already exploring ways to incorporate doulas into their facilities. This bill encourages that we work and allows prisons and local jails the flexibility to create standards and protocols unique to their communities, and if and when doulas can be helpful for their populations. We've just spent a long time about people giving birth in Tennessee in prisons, and often jails do have to do so alone. So this bill would allow pregnant, incarcerated women to have the support of a trained doula at the discretion of the correctional facility. So doulas are not specifically midwives. They provide support. They could also help take some of the pressure off the facility and some of the families. So they help pre-birth and they help after birth to provide support services for people. So incarcerated people have a higher risk of delivering a preterm or low birth weight infant than non-incarcerated people. Allowing incarcerated people to have access to doula services, which have been shown to reduce rates to preterm birth, C-sections, and use of epidural pain instrument assisted births, associated medical complications, and chronic conditions, and increases the rate of breastfeeding and spontaneous vaginal births, has the potential to improve the outcomes for both birthing people and their babies. The state currently pays the childbirth cost for people who live in Tennessee jails and prisons. Allowing birthing people to have doula access could save nearly $400 per birth due to the cost savings associated with improved health outcomes. Doctors who treat pregnant women, pregnant incarcerated people, should focus on the medical needs of the patient and child.
Excuse me, Representative, I failed. You're describing your amendment, and we didn't put your amendment on here.
Okay.
I am sorry. That's my fault.
Okay, and
There's a motion on the amendment. It's, do you have 0015247?
yes, sir.
Is that what you have? All right. Motion and a second on the amendment? Second on the amendment. All right. All in favor of putting the amendment on the bill, say aye. All opposed, no. All right. Now your amendment's on the bill. You're in the right posture, and this is my fault. I'm sorry.
No problem, because the amendment does make the bill, so it both slipped through both of us on that
All
one,
right.
so
Continue.
no problem. So this General Assembly has supported legislation improving the support for pregnant people in Tennessee. In 2020, we passed prenatal care bill with the support of many of our members that prescribed minimum standards for pregnant incarcerated people. In 2021, we passed recognition bills recognizing doulas as vital members of childbirth team. With this bill, we can continue to improve circumstances for Tennessee mamas and babies. Why do we need this bill? We have specifically heard from people that work with pregnant incarcerated people, including Free Hearts and some practicing doulas in Tennessee, that giving back childbirth alone, because those who would normally be in the room aren't granted facility access, is a real concern that pregnant women and people are dealing with right now. This bill would allow these people to have access, to have the opportunity to be treated with dignity during childbirth, and have someone specifically advocating for their concerns. So are there concerns about safety and hospital staff? I think we just went through that with the other bill before, so we won't be laboring, we won't go through all that. But this bill is entirely permissive, and it gives the correctional facilities discretion to allow pregnant people to have access to doulas. There is not expected to be any associated costs with this bill, and this bill assumes a volunteer doula programs like the ones that already exist in other states. And with that, committee and chairman, that is my explanation.
Okay, questions for the sponsor? I have one while they're thinking. Where does the root word come from for doula? I have never heard the word. Where does it come from?
If you want to go out of session, I can get that answer.
Oh,
for
that's
you
all
real
right.
Quick.
Okay.
It would take, but it would take but 1 second because they have an expert right here with
That's
me.
all right. I was wondering. Let me ask you a question. Let's say that a doula comes in and goes in a prison setting to be with a pregnant inmate on pre-birth. Let's say 2-3 weeks before birth, and she gets assaulted in the jail or in the prison by another inmate or gets hurt. Who pays for what it's going to take to treat her, and does she have standing for a suit against whatever correctional institution she was in? Do you know?
Well, I can't speak to that particular incident, but I'm sure there's procedures and policies, and we might could ask TDOC of how they protect those particular people and give them the access that the programs that they have now, how it would continue to be in place. Because right now they granted the appropriate facility access, and I'm not sure, I cannot speak to TDOC's security protections and how they do that.
Okay, thank you. Representative Moon?
Thank you, Mr. Chairman. At this time, could we go out of session and hear from TDOC? And also to address this liability issue?
That's fine. You came prepared to speak on each bill, didn't you? Okay. We're out of session.
Hey, Chairman. Tory Grimes, TLC, Senior Counsel and Legislative Liaison. We're neutral on the bill because it is permissive. I think from a programmatic perspective, some of our rehabilitation folks were interested in mapping out what a program would look like. And so we're not there yet, but there are several surrounding states, Alabama specifically, that do have similar programs. And typically, at least kind of how we potentially would envision it would be consistent with what our normal volunteer programs are. And to Chairman Moon's point, volunteers in the prison system by statute are considered state employees for purposes of filing a claim in the Claims Commission. So that would be their remedy if the inmate, say an inmate assaulted a volunteer, that volunteer would then have, I think I misstated that. They're a state employee for purposes of their to the extent they're volunteers. So the remedy is the Claims Commission. So if the inmate had a claim against that person's covered. Now, typically they're kind of quasi-state employee in that window of doing the volunteer work. So I would presume that would have to apply the same way it does for me.
This bill would also apply to local jails. And can you speak to the liability of the local jail where this concern is with volunteer?
I cannot, Chairman.
Thank you, Mr.
Any other questions for the witness? All right, thank you, sir. All right, we're back in session. Any questions for the sponsor of the bill? Chairman?
Thank you, Chairman, and not necessarily a question. Again, I'm going back over there in that direction, looking specifically at those two gentlemen, Chairman's Moon and Eldridge. I mean, Chairman Dixie, until I'm assured that our local jail would not be liable for anything, and I can't support this. I just can't because of that sliver of liability. Sure, I know it's permissive. I get it, but still, I just have that fear because I represent rural Tennessee, just as rural as you can get, and our budgets are just, well, paper thin. I just have I just have a concern. So with that, and I know you can appreciate that. So with that, I'll leave it. But you know where I'm going. I'm going to go down on this. But thank you for this. Appreciate it.
Okay, any other, yes, sir.
So, like, to talk about the liability that we have in here, I think we have to go back to the definition. It's a volunteer. We already have volunteer programs in prisons. So, I mean, this would extend to, if your concern would extend to the prison ministry, when a lawyer comes in there, when they have all this stuff. So there's already protections and procedures in place. So I can't say that I agree with you that there's a sliver of liability, because yes, there's liability on those other programs. So those programs were allowed into prisons, and those are voluntary programs. So what would be the difference here? And I just ask you to consider and ponder that as you consider voting for this bill.
Yes, sir. You're recognized.
Thank you, Mr. Chairman. And to go off of what Chairman Kiesling was saying there, and I go back to the local situation that we have back home, where we have, at one time, we had almost 400 inmates in a 255-bed jail. There was nowhere that anybody could meet. The lawyers didn't have a room to meet in. So there's situations out there. I don't think mine is the only one. So the question is where would they even have an opportunity to meet in some of these local facilities? And I think that the liability is very heightened in a situation like that. And I feel like that we would be putting ourselves. I don't, you know. I know we have a couple of guys that goes in and holds a service with the inmates on Sunday morning, but I mean we got people laying in the hall. I just, you know, I feel like we're opening the door for more issues there, and I just can't help but be, I'm more from county government. And I just see what the problems have been in the past there. And I know, we talked about, Department of Corrections, and they got a heck of a lot bigger budget, so that's my concern.
Okay, yes, sir.
Again, this is permissive. If you don't have the capacity to do it, it won't be done. Number two, I think that, this program is going, when a woman or a child is born in prison, they're already born in a deficit. So we need to make sure that they have the support staff so that at least that baby can get off to some sort of equal standing and put in a familiar situation with people they know and they understand, so that child will be taken care of until that person is released from whether it's a jail or it's a prison. I think that's incumbent upon us as the government to do that. So I have to go back to keep saying that if you're worried about the liability and all this and these things, then we need to cut out all the volunteer programs. So in that instance, when they go and they have these Sunday services and you got people stepping over each other in the halls, what's to prevent them from attacking the minister from coming in? What happens in that instance? So we can't pick and choose when it's available for us. We have to make a blanket sheet for all. And let's be fair about what we're doing this. And let's also consider there's an innocent child that is starting a life in prison, in jail. And how do we make sure that that child doesn't end up in the circle of violence or a circle of influence and get back into prison? How do we break that? And this is the way to start it, to help them with the childbirthing process, help their families, support them throughout the system, and get them off to a positive start in life. And I think that's what we all want here.
Okay, Representative Powell.
Thank you, and I appreciate those sentiments. I think, and I appreciate, my colleagues represent rural districts. I just want to, I represent an urban district here in Nashville, and I do think that we have the capabilities and the facilities, and so I would say this is simply a permissive bill that would allow those places that might want to offer these services the ability to do so. And, I think, and I'm fortunate to have two young children. And, I know other families that have used doulas and feel comfortable with doulas, and it helps the pregnancy. And they can be very beneficial. And so anything we can do, I think, to encourage safety, health, and wellness of a child as it enters this world is something we should strongly consider and really lift up as an option. And so while I know that this might not be feasible in some of the rural areas, the part I like about it is it makes it permissive so that in certain communities and places and perhaps at the state level, we could utilize this service. You know, and I get the fear of lawsuits, but you know, I wouldn't get up in the morning if I was so afraid of lawsuits. I'll tell you that. So, you know, I certainly think what we need to, though, focus is not necessarily on the lawsuits and the liability, but on protecting children when they enter this world. So I appreciate your passion for this and bringing this legislation, and hope my colleagues will look, you know, consider the arguments that I've made and vote favorably for the legislation. Thank you.
Thank you, Mr. Chairman. And just in closing, if there aren't any more questions, but I do want to, I want the committee to consider that there are people that can really use this particular, this service right here. And if it can help 1 or 2 babies or 5 babies or 500 babies, I think we should not take any option off the table just because you feel like it may not work in your particular area. I think there's an opportunity that it can help the masses. And I think that we should look at it from the 100,000-foot view and make sure that we understand that it is permissive, and if it leaves an option on the table to help a family, then I think we should. So thank you. With that, Mr. Chairman, I close.
All right, thank you. Representative Eldridge.
I'm sorry, Mr. Chairman, but there's just something that crossed my mind, and I don't know. I'm asking honestly. I don't know the answer. How long does the child stay with the mother when there's a situation where she's incarcerated? Is there a time limit where?
Honestly, I don't know that answer too. I would have to. I'm assuming that it may be dependent upon the birth and if there's any complications, but I have no idea.
Okay. I have no.
Hold on 1 second. Hold on 1 second. I got it. Yeah. Hold on 1 second. And normally it's just a hospital stay, which I think when a normal birth, I think that was the normal birth is when they receive medical care, and it's normally like I guess a normal birthing period, 2 to 3 days, no more than a week. And that's in the hospital. That's the hospital stay.
That's and so the child is going to be removed from that mother at some point, and it's going either to a grandparent or
the father or
father, somebody,
right.
And you know, I know we're focusing on what's good for the child, mm-hmm. but the child at some point is not going to be with that mom while she's incarcerated.
Correct, and that's where the doula comes in. The doula helps that transition, and it helps make sure that that transition to the parent or that custodial guardian goes smoothly, and that parent is that custodial guardian is prepared for what they're about to do, and make sure that the mother understands what's going on so that they can have an ease of transition. That's what the doula is for.
Okay, thank you, Chairman.
All right, any other questions? Chairman Moon.
Thank you, Mr. Chairman. I apologize, Mr. Chairman. I could support this as a pilot program in a state institution. Having said that, I really have issues, again, with county jails. They're stressed to the max at this time. So thank you, Mr. Chairman, and thank you, sponsor.
Again, the bill is I'm sorry, I spoke out.
Go right ahead.
So again, it's permissive. So a county jail can use it if they want to. If they don't, then it's okay. But that's what I'm saying. But don't take away from the opportunities. Even like in Davidson County Jail, that's a bigger jail. They may want to try it. But in your county, they may not want to try it. That's why it's permissive. So I say, let's give it a try. If it doesn't work or if it has some issues, then we can always come back and fix it as we do. But I feel like this is something that's going to be good for the state of Tennessee. I think the TDOC and some other areas look favorably on this, and they're actually looking at programs to try to make this happen. But I think this will help give them the opportunity to make that happen.
Okay, any other questions for the sponsor of the bill? Question been called for. We are voting on House Bill 1947. All those in favor say aye. Aye. All opposed, no. I believe the bill fails. Thank you, sponsor.
Thank you, Mr. Chairman.
We're
Thank you.
now on House Bill number 52255 by Representative Harris. Motion? Second? Go ahead, Mr. Harris.
All right, thank you, Mr. Chairman. So there is an amendment on this bill, and that's amendment number 015337.
That's exactly what I have.
All right.
You want to explain the amendment, or does it make the bill?
The amendment technically makes the bill because we only made some
Okay,
small
then we
alterations.
probably need to put it on the bill and then let you explain.
Absolutely.
All right, do I have a motion on Amendment 15337? Motion? All right, all those in favor of attaching this amendment to the bill say aye. All opposed, no. All right, it goes on the bill.
Thank you, Mr. Chairman. So House Bill 2255, with the amendment added to it, does make a couple alterations that will improve the format of this piece of legislation. One of those is that I did place a restriction of 50 minutes of outgoing telephone service calls for juveniles with good behavior. And instead of restricting it to the 50 minutes, there are some of our departments do actually go over the 50 minutes in some cases at this point right now. And so I put at least, so that way it does not stop them at 50 minutes. The other addition to this bill language is that this section does not apply to a facility or a Department of Corrections or a contractor providing correctional services if the facility or contractor is a party to a contract for the provision. And so until that contract that they are currently in completely ends, this piece of legislation does not go into effect to not interfere with their current contracts. So the fiscal note on this bill would increase the state expenditures by $3,600 in the next fiscal year and every year after that. For the dozens of children currently separated from their families while awaiting trial inside of a county juvenile court or detention center, the cost of calling home often presents a barrier to keeping in touch with their parents. The fees for a family to pay so they can reach their children and receive those calls can translate to often financial stress. Currently, DCS does not charge for those calls. DCS policy currently says that youth can only make 5 telephone calls per month, but DCS practice is at a minimum of 30 minutes of calls per day, 5 days a week is their current practice. Currently at DOC, they charge 14 cents per minute at about 122 minutes per week per juvenile, and this bill would cover about half of that cost for the juveniles per week. Once this bill was placed on notice, I received dozens of emails and a few phone calls from people in support. One lady gave me a call from East Tennessee who said that this legislation, in quotes, couldn't come soon enough as I can't afford to fund my 15-year-old daughter's phone account, let alone consider the cost of bond or a lawyer, which might have let my daughter await trial at home for the past month instead of in lockup. In 2018, the local jail in Shelby County, where I am, averaged about $3 per call. With the help of our local mayor and county commission, they made it that all outbound calls for juveniles was put down to $0, zero cost. And so over the last few years, data has shown in Shelby County that it has helped us with our recidivism numbers. Our DA, currently, she is also the president of the DA's conference. She taunts that we in Shelby County have some of the lowest recidivism numbers. And so a lot of that comes from some of the policies that we've put in place. And so I'm elated to be able to carry this. This bill would allow for a juvenile to speak to a member of clergy as well, if not their parent or guardian.
Okay, thank you, sponsor. Questions for the sponsor on the bill? Well, they're thinking I have one. What do we say to jail with an unfunded mandate here, telling them that they're going to provide this service and they're not going to be reimbursed for it if they're used to paying 14 cents a minute or however the contract reads?
Yes, so Basically, this would basically put that cost onto our jails to have to fund that piece of allowing the juveniles to have that connection with their parents while they're still in the system during that time. And so that does not get covered by a contract in any kind of way or by that child.
Okay. The way your bill reads, at least if I read it, it's for outgoing calls.
Outgoing calls. So any calls that come in receiving from a parent, obviously they would have to put funds on the books. But for that outgoing call during that time when that child would like to speak to when they have that allotted time that is given permission to them for having good behavior that is given to them, that allows them to make those phone calls. So that's what this does.
Okay. But the way it is right now, if a parent calls in to a youth development center, they can talk to their kid, can't they?
So I can't specifically say how it is for them, how they receive. I've only been working on the outgoing side of it.
Okay. Representative Eldridge.
Thank you, Chairman. Are these calls monitored?
So on every call that, as the child is calling out, there's somebody on the other side on the initial part just to make sure that that person that they are speaking to is somebody that is on the list for them to speak to.
What happens when that? They're not going to be on the call the entire time. So what happens when their call is turned over to somebody else, maybe, a friend or girlfriend, boyfriend, whatever, mom's called in and talks for 5 minutes and then they turn it over to somebody else. That's always a possibility.
So I believe that's all, like you said, it's always a possibility. Currently, I'm sure it's a possibility right now in the current policy, so I'm not really sure exactly how they may manage that currently, but I didn't address that in this bill.
A facility up in our area currently, they do 40 minutes. It's free. And they use it as a tool for good behavior and all. If you do something out of line, they'll deduct 10 minutes or they'll deduct 5, depending on what it is. They use it as a something to promote good behavior and everything. And I don't know that they monitored the calls. I don't think that they brought up the fact that it's got to be a certain person that they're calling, So in a sense, are you going to be restricting more so as to who that person can talk to, the incarcerated person?
So no, this does not restrict who they speak to outside of, this is only to cover the cost of the funds for the conversations between them and the actual parent. If they already have it in policy to allow them to talk to just anyone that they would like to, this does not stop them from doing so. This bill right here only is specific for good behavior juveniles, and it just allots the 50-minute minimum. So I've spoken with a lot of different jails, and so they've also said the same thing, is that they do give allotment, and a lot of that is for good behavior, and so obviously that feeds into what this one is as well, where good behavior is rewarded and at least given to them to be able to have that conversation, so that when they get out, they don't feel like they are left alone and that they don't have anyone of support. So,
Any other question for the sponsor? I like the idea. I do, and I think it's important that you maintain communication. I have a little heartburn over telling the jail they're going to do it and spend money. We're making them do it by the state, even though it's not a whole lot. Chairman.
Thank you, Mr. Chairman, and I do too. I have a little bit of heartburn on that too. Jim Lehman is here with the DCS, but I don't know. Chairman, I haven't spoken with folks over there. This does apply, I think, to them. Would you're saying no? He's saying yes, but anyway, would I be out? Do you mind if we go out to session just a moment?
Not at all. We'll go out of session. Go ahead. Come up, sir. I mean, it's 20 minutes till 6, so just take your time. Please state your name.
Good afternoon, Chairman and Committee. My name is Jim Lehman. I'm with the Department of Children's Services. Happy to respond to Chairman Kiesling's question if you like. The department was defer on this legislation because I think, as the sponsor mentioned, we do offer free phone calls to the use. Now, yes, the legislation would apply to the Department of Children's Services because of the YDC that we operate. But we were defer on the legislation because we offer phone calls to our use at no charge.
Okay, thank you, Chair. Now, say that last part again, Jim. You do what now? Sorry.
We offer, we allow the use to have phone calls for no charge. The typical youth would get 5 30-minute phone calls a week at no charge.
So 5 30s. Okay, and that's
which is
weekly.
150 minutes, I guess. Yeah.
Okay, weekly. Based on I take it good behavior. Then, right? If they get out of line, no. Is that how's that work?
It's my understanding that it can be adjusted for behavior. But in talking with our deputy commissioner over juvenile justice, that the goal is to try to get the bulk of the youths to have that 5 30 minutes, just to keep, so that they can stay in contact with their family and all that kind of thing.
Well, Mr. Chairman, I get it. So the 5 30s, that's inbound or outbound, doesn't matter, right? Or does it?
I haven't asked that. I think it's typically done on an outbound basis.
On an outbound?
Yeah, the
Strictly.
youth would be calling. I think
to your knowledge, it's strictly outbound then.
I wouldn't say strictly. I don't know for sure, but that's my understanding of the usual practice.
Okay. Thank you, Chairman. I don't think I have anything else.
The other question, yes, Chairman Littleton. Oh, I'm sorry. I apologize. Yes, I forgot. Representative Powell, go ahead.
That's all right. Sorry. Can you speak to why these calls are allowed? And I don't want to put words in your mouth, but just kind of the mental health of the children, the ability to communicate with their parents, making them, I'm going to say, better in the facilities. But can you speak to why this is kind of a best practice and why this is allowed?
Sure. Thank you, Representative. Happy to do that as far as someone that's been at the Department of Children's Services for 3 months. But as far what I have heard from our Deputy Commissioner of Juvenile Justice and others that work for our Juvenile Justice Division is that the policy is in place just to ensure that ties and relationships are kept with family members and that kind of thing. That's about all I can speak to. That it's what's good for the youth.
Okay. Thank you so much.
Representative Little or Chairman Little.
Thank you, Mr. Chairman. And I do believe that the parents can call in. Did we not? We did discuss that as well. And I do think the phone calls are used, they're given for good behavior. And I think maybe taken away for bad behavior. So they're kind of there to keep the conduct and the discipline up as well, right? Mm-hmm. Good discipline.
Yes. Thank you, Chairman. And as I said earlier, and I think as the sponsor read too, that, our actual policy on paper is lower than the 5 30-minute phone calls a week. But, I think the goal for most of our use is that 5 30-minute phone calls a week. But yes, it is possible to, be adjusted for behavior and that kind of thing.
Okay, any other questions for the witness? All right, thank you, sir, very much. All right, we're back on the bill. Any more questions for the sponsor? Representative Powell.
Yeah, and I guess this committee is not here to look at fiscal notes and fiscal impact. There's a whole other committee for that. But I would just say that as a society, what we're not seeing is the societal savings that this does. When you have juveniles who are able to make these phone calls and I think help them to continue to maintain a relationship with a parent or family member that helps support them through a very difficult process. hopefully improves our recidivism rate in the state, and essentially, I think makes them all around better people. Is the I appreciate what was just said, and makes them happier and healthier. I think that this is a very minimal cost, and something that in the long run we don't factor this in, but is the savings overall to the state. Because if you look at the cost of this, and you compare that to just one or two incarcerated individuals, that's thousands upon thousands of dollars that we're paying. So, this is a small thing to, in my opinion, ultimately save millions upon millions of dollars by just allowing this simple policy change. So I commend you for bringing this. Hope my colleagues will consider that and vote for this favorably. Thank you.
Thank you.
All right, any other questions for the sponsor of the bill? All right, we're voting on House Bill 2255. All those in favor say aye. Aye. All opposed, no. Oh, gee whiz. All right. Madam Clerk, will you take a roll call vote?
Representative Eldridge. Representative Eldridge votes no. Representative Kiesling. Representative Kiesling votes aye. Representative Littleton. Representative Littleton votes no. Representative Moon. Representative Moon votes no. Representative Powell. Representative Powell votes aye. Chairman Hulsey.
Aye.
Chairman Hulsey votes aye. Ayes 3, noes 3.
I'm sorry, the bill fails. It's a tie.
Thank you, committee.
All right. We're on House Bill 6, which is 2610, who has been taken off notice. Not who has. The bill has been taken off notice. Item number 7, House Bill 2571 by Representative Doggett. Got a motion and a second. Representative Doggett, or Chairman Doggett, you are recognized.
Well, good afternoon. I hope to complete
got
these
amendment.
two presentations.
I'm sorry, you have an amendment, right?
It's quite possible, yes, sir.
All right, let me get the right number here.
I have 14293.
That's what I see as well. All right, is there a motion on the amendment? Is there a second? We're voting on the amendment. All in favor of putting amendment on this bill, say aye. Aye. All right. The amendment is on the bill. Now you can proceed.
Thank you very much. The amendment makes the bill, and what we are seeking to do, if you'll recall, post-certified officers, law enforcement officers across this state complete in-service each year, and as a part of that in-service, they receive a salary supplement of $800. Correctional officers in our local county jails do not receive any type of salary supplement. Now, they are required to complete in-service training each and every year, and so what we are hoping to do is put this $800 training supplement in for correctional officers. Now, I can tell you as a former correctional officer in my local sheriff's department, where I started in 2010, my pay, hourly pay, was less than $9 an hour. State averages are roughly $12.50 right now. We are looking for ways to keep correctional officers in the jail. We've heard a lot of testimony already on different bills that dealt with correctional officers so far, and so we certainly want to make sure that we don't have shortages, even though that may happen from time to time, but we want to bring this supplement forth. There is some criteria that has to be met. They have to be employed at least 8 full months in order to be eligible for that and go through the TCI training that is mandated. And if they have to complete their 40-hour in-service as well. So if you have any questions, I stand here ready to answer.
Thank you. Any questions for the sponsor? While they're thinking, Post funnels the money for police officers and their in-service. I'm just asking for how it's postured. Will this be placed in a TCI budget and funneled out that way?
Yes, sir, that is the intent, and I've spoken with the director of Post earlier today, and he said that they are willing, because they already have the system set up to do this, they're willing to collaborate with TCI and help them in that process, access to their software and things like that if needed.
Okay. Any question for the sponsor? All right. Looks like we don't have any. We are now voting on House Bill 2571. All those in favor say aye. All opposed, no. Ayes have it. Bill passes to full committee.
Thank you, Mr. Chairman and committee.
And now for your next bill is House Bill 0071. And we have a motion and a second, I believe. All right.
Yes, sir.
Chairman,
There is
you
an
recognize
amendment.
on this bill.
I
Is
have
there
an
an amendment?
Yes, sir, I do. 14790.
That's exactly what I have as well.
Fantastic.
All right, a motion on the amendment and a second on the amendment. We're voting to put the amendment on the bill. All in favor say aye. Aye. The amendment is now on the bill. Please proceed.
Thank you. And the amendment makes the bill, and what we are doing here is currently we have experienced our local sheriffs in their jails have experienced some issues in the past where a parolee is violated, and so they end up having some time where they sit in jail waiting for their revocation hearing, in which there's that lull of time where the locals are not being reimbursed for housing that state inmate. And so now we are putting what has been said to possibly be in rule or in practice. We're going to put it in code with this right here to make it available. It will require that our local jails are reimbursed for that period of time in which that parolee is there in their facility.
Okay, any questions for the sponsor? Call for the question. We're voting on House Bill 71. All those in favor say aye. Aye. All opposed, no. The ayes have it. House Bill 71 goes on to full committee.
Thank you very much.
Thank you, Chairman. I'm sorry. All right, we've got to come back around here. Yeah, exactly. But all right, we're up to item number 9, which is House Bill 2748 by Representative Towns. Representative Towns, you are recognized.
Thank you, Mr. Chairman and members.
I need a motion. A second. Second, go ahead, Representative.
Mr. Chairman, thank you for that again. House Bill 2748, Mr. Chairman. What I'm going to do is that I've met with some of the people consequently after the bill was drafted and had some things explained to me. And there is just to give you a little background, the vendor service in the jails, they have set the situation up themselves, paid for it, whole 9 yards. They split the money with the Department of Corrections, so to speak. And so I wanted there to be some competition, okay? But after, talking with them a little bit on that particular deal, I really would like to take it off notice, okay? Because I don't think I can get the synergy and the savings that I'm interested in right now. Okay.
All right. Thank you, sponsor. Without objection, this bill's off notice. That moves us to item number 10, which is House Bill 2750, also by Representative Towns. You're recognized.
Mr. Chairman, members, thank you as well.
Need a motion? Need a second? Second. Proceed, please.
Thank you, members. Now, members, this bill is a little different. As you know, all of us are experiencing, unfortunately, inflation, okay? And everything's going up. Everything costs. I mean, as I said earlier today, a burial plot costs so much money today, it's unreal. Inmates don't have money. And so to make phone calls, what happens is that, who's paying for those phone calls? It's their mom, their grandmother, somebody of that nature. And it's interesting testimony y'all had here earlier today. Phone calls are certainly a vital link from there on the inside to them keeping in touch with the population on the outside, hopefully to keep them psychologically regulated, where they are wanting to improve their lot and get out. And so we want them to be able to communicate, but we don't want to break grandmother in the process. So what I'd love to see there be some reduction in the cost. I know the cost of calls have gone up just a little bit, and what a time for the cost of a call to go up. I think it's gone up 3 cents, I believe. And I think the averages I've been shared with me is about 11 cents across the state. And there's a date of trying to get it reduced by 50% in the next 3 or 4 years, just to reduce the cost so people can communicate. People that don't have any money, they don't, like, if they work in there, I guess they do have a little money to put on the books. Obviously, everybody's not working, but I do know that this has come up in town hall meetings. Who's paying for it is the dad and mother, the grandmother. That's who's paying for it. And if you are a grandmother on some kind of Social Security, you don't have a lot of money at all. Unfortunately, to say it, every little cent helps them to pay for bills, food, and whatever, rent, medicine, whatever. So essentially what it does is just seek to try to get that cost reduced at some point. And I think, like I say, it's projected off to year, I think, 225. Gives them 3 years to kind of look at, see if they can reduce it. And it would be how they decide to reduce that cost with that vendor. That vendor will have to come up with a way to try to reduce the cost of those calls. Essentially, ladies and gentlemen, that's what it does. That's what we're trying to do, make it a little bit more affordable for people who are on the inside and somebody on the outside having to pay for it, which they don't have a lot of money. You know.
Okay, you've heard the sponsor's explanation of the bill. I agree with you. I don't know how you're going to control 7% inflation for the next 5 years on that deal, but I understand what you're saying. Any questions for the sponsor?
I know.
No questions at all. All right, we are voting on House Bill 2750. All those in favor say aye. Aye. All those opposed, no. I'm sorry, the bill fails.
Okay,
there.
Mr. Chairman, members, thank you.
Thank you, sir. All right, we are back to House Bill, what was it? 2875. Let's see. Leader, you're recognized. Give me a progress report, would you?
So, thank you, Mr. Chairman and members. I did get a chance to go out and talk with the sheriffs, and they are willing to work with me on some new language. We're that close, and we just got to set a time when we're going to sit down and work out the language. They've agreed to that. So I wasn't sure if at this point, since this is your last committee, we could adopt the amendment, which that's the one that they would be working off to get this close. And then we work on it going to full, and if it don't work, we just don't move forward.
Okay, if I'm understanding you right, you want the committee to vote the bill out between now and the full committee and work this out?
Right.
I don't really like doing that.
Okay, well.
What I'd rather do is, if this was going to be our last calendar, I'd rather have one more week.
Okay,
That'd give you the time to get a timely filed amendment and do it the way you want to do it, is what I'd rather do. It's up to the committee, though. Say again.
I don't mind keeping it here.
Representative Eldridge, Chairman Eldridge.
I make a motion to adjourn.
There is a
Chairman.
motion to adjourn, and there is a second, and I'm hungry, and so we will come back to hear this one bill next week in a special calendar. Yes, we will.
So let's just say that the remaining bills are rolled to our next meeting.
We're adjourned. The remaining bills are rolled to the next week.